Well, how often have you seen the Supreme Court of India make policy changes after there has been a judgment from a particular high court? That's exactly what happened when Justice Rajiv Shakdher, while he just had embarked upon his judgeship journey, had written that landmark judgment on how to recruit talent as judicial law clerks. Justice Shakdher is known as the man of integrity in Delhi High Court, which is his parent High Court. Thank you so much for being with us, Justice Shakdher, today.
Thank you for having me for an interview, Roy.
So, how do you think you have accomplished, or do you think you have accomplished all that you have set out for in the 16 years of judgeship journey that you had?
First of all, Roy, let me just make that minor correction. I've done more than 16 and a half years. But having said that, when I was invited to the bench, it was not as if I, sort of had a mission in mind. I evolved as a judge, and whatever I have done is really, in my view, for lawyers, litigants, and other academic scholars to evaluate. And whether I have or I have not accomplished, it is actually their call. So that's how I look at it.
Right. Uh, Justice Shakdar, in your farewell speech, you had said that you had come from an affluent entitled background, and it was very difficult for you not to break into the legal profession, and several others are not as lucky as you. Why do you think that is? Why do you think that you had a easy entry into the profession?
No, Roy, I didn't say that uh, others don't, in a sense that I had an easy entry and others did not. What I did say was that there are some who are entitled, and I thought even I fell into that category. Why did I say that? Was that I had a roof over my head, I had good education. My parents were not affluent as is understood ordinarily. They came from a service background. My mother was a principal of a school. My father was into private service. I had members of my family who were in the bureaucracy. So, to that extent, I was entitled, if you can call that as entitled. There are others who don't even have this. When they come into the city of Delhi, I have known of youngsters coming from far off places trying to make a life for themselves in this profession. So it is difficult for them because you don't know anyone. I didn't have any godfather in the profession, i.e., as in a father or uncle who was a lawyer or even a judge. And when I entered the profession, I had qualified as a chartered accountant and also as a lawyer. So therefore, I thought I was reasonably qualified to at least make a cut into a good chamber. Uh, but then I found it difficult.
Okay.
I went from a solicitor firm to another solicitor firm to senior lawyers' chambers, and everyone would meet me and say, "Yes, come back a month later, a week later," and it didn't fructify. Uh, so therefore, it gave me a sense of disillusionment at that juncture. But then finally, I got into a good chamber. In a sense, I was made to interact with Mr. Soli Surabji. And when he found out that I was a chartered accountant, he sent me to one of his best juniors, which was Mr. Harish Salve. And mind you, at that time, Mr. Salve was himself not a designated senior lawyer. And it turned out to be a fruitful stay in that chamber. I picked a lot by just watching him. And as he grew, in a sense, I grew in the profession. My association with him was, I think, about 2 years or so, but it was fruitful.
One of the Supreme Court judges had recently commented that the most difficult part of a lawyer's journey is to get inducted into a good chamber. And while you were sharing your story, I realized that having gone into the chamber of Mr. Salve would itself have probably been a turning point in your career. If correct me if I'm wrong.
Yeah, getting into a good chamber is tough, as I just explained to you. I got a recommendatory letter from no less than Mr. J.V. Dadachandji, and I still had difficulty. But fortuitously, I was made to join Mr. Salve, and Mr. Salve is where he is. All of us know, and I learned my skills about analysis, courtcraft by watching him. So yeah, I did get lucky, though I didn't know at that stage where Mr. Salve would end up. Uh, so, as I said, he was not a designated lawyer. The advantage of entering his chamber at that juncture was that he used to flit from court to court. I remember Mr. Salve doing the income tax appellate tribunal, the High Court, and the Supreme Court. And at times when he couldn't reach, he would give us the liberty of getting up and arguing, say in the income tax appellate tribunal, which is an opportunity
Yes.
that is rare, and equally rare that it comes to you when you are still young in the profession, because it allows you to open your mouth, get over your initial hesitation. So yeah, I did get lucky in that sense.
This is Shakdher. You had a booming practice. After you graduated from law, got into the illustrious chambers, till you established your independent practice, till the time you were elevated as a judge. Um, if you could share with us, what was that key factor that made you accept judgeship and leave your practice, firstly? And secondly, do you feel there are any deterrent factors why a lot of other legal minds, brilliant legal minds, do not join judgeship, as very succinctly put by Justice Call while he was hearing the collegium case, that we have been pursuing so many young lawyers to join the profession, to join the bench, but they don't want to because of delays by the government, etc. Of course, these were the reasons given by Justice Call while he was on the bench. So why do you think, is there, as per you, are there any other kind of deterring factors, and what for you was the factor that made you join judgeship?
See, when I was called by the then Chief Justice, and I was informed by other senior judges that you'd be invited to give your consent, I was already designated as a senior advocate, and I had a 3-year run, which was, from by all counts, a wonderful experience, both in terms of the kind of work I did, and of course, the remuneration which comes with that kind of work. But and it could only have got better,
Yeah.
correct, as you grow in the profession. But I was trained, or I was exposed to an environment when uh, the Chief Justice of the court asks you uh, to join the bench, you ordinarily don't say no, because it's an honor that they are conferring on you. There are several others always ready and willing to do that. If they have thought it fit to ask you, or the senior judges have asked you to join the bench, then uh, you should have a very good reason to refuse that. It is a service to the nation, to the country, to the litigants. And it is my belief, if good people don't get into the system, then the system suffers overall. The other part of your question as to why um, the best legal minds have not joined the profession, uh, my answer is twofold. One, that outstanding lawyers have joined the profession. In fact, there have been some lateral entries in the Supreme Court, and all of them uh, had enormous practice.
Right.
But when they were called upon to join the bench, they did. As to ones who were perhaps asked and did not join, all of them may have had their own reasons. Uh, and it is really for them to answer. I gave you why I joined.
Of course.
But I have always believed, and this is something that I have articulated several times, that good lawyers should join the bench even for a short period after they have had a run in the practice, become financially sound, taken care of their liabilities, and then give the best to their system. It is like having a short service commission in the judiciary. It's an experiment I think the policymakers should look at, because then you're free of all anxieties also, I think, which perhaps legitimately they are when you're in service. You're financially comfortable, you come in, you give in your best, you get out, and then you practice again. Uh, the response that I got when I was, articulating this suggestion was that, you can't practice in the same high court. To which my answer always has been, if you're good, uh, you can appear in other high courts and you will do well. And especially in Delhi, I don't see any reason for people to not accept such appointments, because you have the Supreme Court here. You can practice in the next court. So that's how I look at it.
Okay. No, because there have been a lot of past instances where lawyers have actually come out in open and said why did they take their names back from being considered for judgeship, and these are all part of record in the Supreme Court, which was discussed, reported. Mr. Sondhi is one of the examples that was very widely told by the bench, is also headed by Court 3. So perhaps the question is for another time, when is delay in clearing of collegium recommendations really a point in time to take back your name from being considered, which has happened time and again. And that is why probably the Supreme Court stepped in to get the house in order and get the recommendations cleared in time. So
So yes, Roy, these are this is really a question which till recently was above my pay grade. So I I
this is
really
beautifully put, huh? Okay.
I have no uh, clear insight as to what happened. But when you are going on record, I don't want to make statements of which I have no factual knowledge.
So the bar in the Madras High Court has considered your transfer back as a big loss to them. And this is despite the fact that you had a very short tenure in Madras. And they considered it a big loss to the bar. They were on record. They had written letters as well, if I'm not wrong. And what was your how was your journey in the Chennai bar, in the bench, and what are the differences that you see when you compare Delhi with that of the Chennai bar?
So to answer the first part of your question, what was my experience in Madras? Uh, when I went there, uh,
You were not happy.
when I went there, uh, obviously I was going on a transfer.
Yeah.
I wasn't happy, but to my utter surprise, I was received so warmly. Uh, you're right when you said it was a short tenure. It was only about 20 months, 20 months to the T. But the kind of reception I got, both inside and outside the court, was outstanding. Uh, Frankly, I loved each one of those guys, and I got, love and affection in equal measure, if not more. Uh, Had it not been for my family, my mother and my children, who were very young, maybe I would have continued there. But then again, these are things that you don't decide. You're like a foot soldier in the legal system. You're told to march, you march. Whether you like it or not, you're told to come back, you come back. And that's what I did.
How fair is that?
Well, that's the way it is, and we must take the good with the bad.
You don't wish it changes.
Well, as I said, Roy, there are things which the policymakers have to look at, and they will look at it. But as I can only answer for myself, when I was put in that position, I took that call. I said, I've been told by those who decide these issues to march, I'll march to Chennai. I've been told to come back to Delhi. I came back to Delhi. That's how it went.
Right. Um, you know, just a slight point that I wanted to ask you here is that when we talk about transfer of judges, nothing, not on your tenure or anything. You just said, you have been a foot soldier, you've been asked to march, you marched. But there have been examples where certain judges have not really marched on that path and things went haywire. Um, some judges who were transferred when they did not want to be transferred, they had even tendered their resignations. Quite discussed, quite on record, quite reported. What is your take on that? Is it fair to opt out of the system when it's not going your way?
See, when you accept the job as a judge, uh, opting out in the middle is like, uh, you know, giving up on something midway. There are people who have expectations from you.
Hmm.
You're a judge anywhere you sit, and if you decide to do the right thing, you can do it from anywhere. So, what difference does it make whether I was in Delhi or Madras? I did what I had to do, right? So, if I had resigned, or if people resign, then you are, in a sense, taking the easy way. Uh, that's my view. People who get very troubled, I can appreciate they taking that decision. It's really a personal call. As I
Right.
look at it, once I put up my hand and I accepted that, I decided to go through the whole period, whatever be the end goal or wherever I end up. So that's how.
With patience.
Yes, that's how I look at it. As I said, you are drafted in. There are people who want you to be there, and if you opt out, they would say that it's all about you and not about the civil society or the country or the nation. You can't make it about yourself. Like a man in uniform, they're also, in a sense,
Right.
people in service. So that's how I look at it.
You had recently stated, Justice Shakdher, judges have no agenda. Their duties and powers are delineated by the Constitution. Judges have no ideology. But this doesn't quite seem to be the case, given how some of the courts have been deciding cases. Do you really think this statement holds true for everyone, or was it only for you?
See, when I said that, I said it because I believe in it.
Right.
And it is not really for me to comment as to whether someone believes otherwise. Uh, it's my belief, it's what I was brought up with, and each has his own
But
conscious
Justice
call.
Shakdher, as a High Court judge, um, as a man in charge of your court, I'm sure you have gone through a number of judgments by several other courts while deciding a case, while putting a point forward. Do you still think that is the case?
See, that's the beauty of the job, Roy. The pen is in your hand,
Hmm.
and if you think a view is taken by another court which doesn't align with your view, but you have the space in law
Hmm.
or in the constitution to navigate around it, you should do it. That's what I did. Unless it's a judgment of a superior court which is binding on you. Uh, you do what you do best, which is stick to the constitution, stick to the law.
Okay.
One of the hallmarks of any robust judicial system is neutrality. And when I said that judges don't have an agenda or they do not have ideology, I meant exactly that. So when you look at someone's journey through law, you would ultimately discover whether he was neutral all along. Don't just go by his last judgment, because that last judgment may be on a particular set of facts. Look at his journey throughout, and then perhaps you may come to a more fair conclusion about what the judge was all about.
I agree with you, Justice Shakdher, but just to take it ahead a little bit, um, Justice Vishwanathan, K.V. Vishwanathan, in a very recent judgment dealing with disability rights in the Supreme Court, had used a sentence that it is a democracy of perceptions, and perception is important in a democracy. Now, just to take it ahead a little bit, there have been so many cases where we see, and not the Supreme Court, high courts included, where lawyers have tried to avoid a particular bench while they are arguing a sensitive matter. They have a perception that probably the judge who is hearing the case isn't going to be fair to the case, right? So how do you see this entire situation? Is it because of the judge who has given certain judgments which are not aligned to a particular view, or it's the lawyer's fault in not trusting the bench? As you said, that you need to take a broader perspective of the judge and the kind of judgments he or she has delivered to come to a conclusion, like if she has an ideology or something like that.
Roy, the best way I can answer this is I've been a sportsman, more particularly a cricketer. As a team, you don't decide, and that's true for lawyers, which pitch you play on. Once you get a pitch and a match is fixed, you must play it. Uh, the matter will get decided. You do your bit, which is represent your client uh, fairly, robustly, and it is for the adjudicator, i.e., the umpire, to decide. And at the end of the day, uh, as I said just now, and I have said it before, people evaluate, they analyze, and legal scholars will decide as to what you did
Right.
while you were there.
Hmm.
So, so it's really not really for the lawyers to, based on a perception or call it pattern, decide whether they would or would not want to.
So it's not fair to judge a judge.
No, that in any case you do. I mean, it would be utopian to think that lawyers are not judging judges. When I say evaluate, they are always. Uh, they are like senior advocates are like generals in a war. They decide as to whether they want to do it or not do it. That's for them to do. But according to me, uh, as I just said, why avoid batting on the pitch? If
Right.
if you get a pitch to bat on and a match, as I said, is set out and fixed, play it.
Right.
The, in a sense, that challenges the umpire also. No?
How to take it ahead.
Yeah, if people had not argued matters before me and had decided based on some perception that this is not the court where I should be,
Yes.
I wouldn't have got the opportunity to say what I wanted to say. So, fortunately, I didn't have those experiences. So,
This is Shakdher. As a chairman of the Accessibility Committee of the Delhi High Court, you have ushered in some revolutionary changes. We'll not speak about it because we all know about it. Um, is there a space in the legal profession which is known to be a dog eat dog for such people? And also, how do we, as a society, ensure that even if we are bringing in all the facilities, we come out of the arena of being a little overtly kind towards the specially abled while dealing with such in, in such a profession. Like you try to make an extra space for them, which is not often taken very kindly by them because they are equals to you, right? You make all the facilities so that they are just at the same platform as you are in. So how do you answer these two
So I agree with
situations?
you, Roy, that they're not looking for empathy.
Yeah.
They're looking for reasonable accommodation so that they can compete. We're talking about differently able lawyers, so that they can compete with those who are completely able. So one of the things that I did, apart from other initiatives that we had, was to put them on Delhi High Court Legal Services Committee panel. The reason that I did that, or on a pro bono panel that we have, is that they should get an opportunity to have their skills being tested in court and earn remuneration as well. When people see them arguing in court, then people realize that they're as good, if not better, than the
Yes.
other lawyer. So this was not empathy or sympathy, simpliciter. It was giving them an opportunity
To be there.
To be there. In fact, in one of the cases, I appointed one differently able lawyer as an amicus curiae in a matter dealing with a differently able litigant for two reasons, and that's my second reason. Is he would perhaps be able to articulate what the person is going through uh, better, and I may be able to appreciate it better. Incidentally, it was also a case of a transfer, of course, in the case in the context of a service transfer. At the end of the day, the amicus curiae put it beautifully. This was when that particular person also had a private lawyer. The reason, as I said, I appointed an amicus is to give me a better perspective. See, it's often as judges, and I can say that for myself, you assume certain things. It is when your attention is drawn to the difficulties that they face, because I have not experienced it, or someone really close to me has not experienced it, is that when you look at it and you at times come up with a better result. So I think that has worked wonderfully for differently abled lawyers who now tell me that putting us on those panels where we can earn and we can also advise and prepare for people and do our bit for legal aid and for ourselves is something that is was very close to my heart.
Right.
So apart from other things that we did, we got an accessibility audit done.
Yes.
And the report is there.
The lifts were completely, revamped.
Because sometimes people think that having a ramp in the building is good enough, and that's
how do you reach the court?
Yeah, that's how. But it is not only about that. It's about how do you access the website. You need screen readers. So to get a holistic view about what was lacking, we got an accessibility audit done. In fact, when I was in Himachal, I, for a very brief period, as you know, coincidentally, a matter was placed before me where the government had, it was an ongoing matter, had placed a status report before the court saying, how their buildings were friendly to people who are differently able. To which my response was that you are self-certifying what you've done. You need an external auditor to tell you whether everything is in place. And then I expanded the scope of that matter by saying that it's all very well for the High Court to tell government to do whatever it has to. What about our own High Court, that is the Himachal Pradesh High Court and this district courts? So I've expanded the scope of that matter by saying that even the Himachal Pradesh High Court and the district courts would get an accessibility audit done. And once the report is there, implement those recommendations if found, useful,
right,
and fill up the deficiency. empathy is not what they're looking for. They're looking for
Absolutely.
equal opportunity.
So, on the question of appointment of judges, I wanted to ask you something. What if it's a very straight question? Which mode do you think is the most appropriate to appoint judges in India at the moment? Is it the collegium system or the NJAC, which was struck down?
See, there are two views about it. There is a view where people say, no, the collegium system, whatever its faults, works better. It's like saying democracy has several deficiencies, but democracy is the best system. The other is, of course, the NGAC. Those who say NGAC is a better system, most of them, of course, do concede that it did require a certain amount of modulation.
Yeah.
Now, that model has never come up before the court for consideration. If that model comes up before the court for consideration, maybe the court would take a different view. I think the jury is still out. If it is worked upon, we could get that kind of a system with modulation. So, till that happens,
So NJAC could be brought back with modulations as well.
that I don't know. As I said, these are issues which the policymakers have to take a call.
Right.
But if they do take that call, they would have to keep in mind what votaries of NJAC say, which is
The
that
independence.
that it needs modulation.
Yeah.
So,
So you've spoken about the use of artificial intelligence and the potential for misuse that it carries along with it. When it comes to listing of cases, right? Do you think artificial intelligence can remove the biases or the institutional biases perceptions that people have while we deal with listing of cases, etc.? Do you think AI can handle that bit?
well,
Or should it remain with the prerogative of the master of the roster?
see, when you talk about technology, in isolation, it seems a wonderful means of sorting out most of your problems. It's not a magic wand that would, in my view, sort out all problems. Much of it depends upon the algorithm.
Right.
Now, it's common knowledge that what you feed in, you get is fed out.
Right.
Now, if your data is in some ways infected, then what you get out as a product will also be infected. So, to remove any such, and if you intend to use AI technology, you must closely look at what you are feeding in. And you can only get good result in this case as well, where you put the algorithm out for people to comment, for people to tell you what is right or wrong with it, and to remove abuse of the system because of infected data. So, as I was telling you, Roy, is that you should also uh, get the algorithm audited so that you know the possible misuse is ruled out,
Hmm.
which is what people, experts recommend.
Is it also time for division of judges in high courts and supreme courts on the basis of subject matter expertise? Do you think it's something that needs to be done? Whether we talk about international commercial arbitration, PMLA, economic offences, a judge a lawyer when he's elevated to the bench, not everyone has a command over a subject that would lead to notable judgments from you. Do you think it is time that the judges are also grouped into the areas they specialize in? Uh, how do you look at it? Or it's never going to be possible?
So, my response to this would be, Roy, that you must elevate judges uh, by looking at what their domain expertise is, so that whatever gaps there are in a particular domain get addressed.
Right.
But having said that, uh, it is good to rotate judges for their own well-being, because uh, they also get stratified, and sometimes you need a breath of fresh air even in that jurisdiction.
Right.
It's been my experience that my colleagues who were, say, not domain experts in IPR, for example, did a fairly good job when they came onto the bench. And why did they do a good job? Is because in an adversarial system, you have two sets of lawyers.
Right.
A judge is trained to iterate facts, is trained to interpret statutes. And most of these statutes which relate to a particular domain are no different in construct. So, a person who's not, say, for example, in the IPR field, is also able to perform in those areas and render judgments which are outstanding, in fact. When you are in a particular domain, you sometimes bring your practice to the bench, your views to the bench. I'm saying sometimes with some caution. Not everyone does that. And then take it forward, which has its own negative ramifications. I sat on the IPR bench, and although I was briefed by some IPR firms as a senior advocate, I did that. But was my practice solely an IPR practice? It wasn't. But I think I did reasonably well sitting as an IPR judge. So,
okay. Has the advent of live streaming increased access to justice and transparency?
well, my view on live streaming is this, Roy. I think it's a very expensive proposition. Uh, Live streaming is of no use till you follow the protocol. In fact, Dr. Debayan had set up a committee to devise a protocol for live streaming. I was heading that committee, and we had judges from all over the country. We were 5, 6 judges, but from various regions and high courts. We devised a protocol which, if implemented, is the right way to go about it. Because once you live stream, you should be able to record the proceedings. Of course, we had given an interval, a delayed recording after 5 or 10 minutes to exclude a possibility of something coming in live stream, which is not really relevant to the case, but something which is, absurd. Someone gets up and makes some noise or makes.
But then you are proposing a pre-streaming censorship.
Not censorship. We are trying to exclude the possibility of, the kind of incidents you've had. Someone playing a song, and an actress was
appearing without wearing any vest.
Yeah, something like that. Those kind of things. The protocol also says that allowed judges that leeway of, um, you know, being in control of the live streaming. In fact, the protocol also has a system where a person would ask for live streaming of its matter, and the other person could also say why it should not be live streamed, and then the judges will take a call. For example, so the the uh, the purpose was that, see, every routine matter need not be live streamed. For example, if it is a landlord-tenant matter, it has no public interest. Uh, After a period of time, when you start storing this data, it becomes too large and expensive. Correct? You would not. Every court would not have that kind of bandwidth. Don't take Delhi as an example, or Bombay or Calcutta as an example. There are some smaller high courts. State governments don't have the financial wherewithal. So it's my view, and several others who are in the system share the same view, is that if the court suo moto has to live stream a particular proceedings, it must be a matter of some public importance. There are several in the high courts. But all other matters, unless the litigant asks for live streaming, uh, why should it be live streamed? I mean, the litigant is not interested in his property matter being put.
To
And
the
if someone
public.
wants to join, we always have VC.
Right.
So suppose it's a family matter, two family
Why should
members are
the
physically in
country
court.
hear it?
Yeah, the others can join. The link is given uh, to everyone.
But you know, Justice Shakdher, even as we speak, Supreme Court has rolled out a beta version of a website which has access to all the courts, all the hearings, 10 to 4. So it is like a website where you go, you click, and the hearing starts. Now, I don't know if we can call it live stream also. It's like YouTube of the Supreme Court of India. You go there and it starts.
Yeah, so
So you think it's not proper?
no, I'm not saying that for a simple reason. That's again, that was not my calling. Whatever decision they may have taken, they may have taken into account.
But you were a part of the e-committee, e-courts.
I was part of a subcommittee, as I said.
Yeah.
The e-committee only comprises of the Honorable Chief Justice of India and other members who are there.
Right.
He had formed subcommittee on this aspect and other aspects, where we were called upon to formulate our views and give it to the Chief Justice.
Like it happens now, you're saying the only constitution bench cases or something like that could be live streamed.
Yeah, because those are matters in which several stakeholders,
Yes,
want an insight. But I'm sure most people won't want to get into areas where it's, as I give you an example, a property dispute or a landlord.
So is it like stretching the concept of open court a tad too much, you feel?
No, I think, Roy, it is also about administrative difficulties. Forget about anything else. I mean, how do you sort of keep that data for long? Because I wish people would read the protocol and they would understand what was the purpose behind it. So suppose it's a defamation case, correct? And the trial is still going on. People should not be able to form a view based on a part of the proceedings and put it out in public domain. It won't be fair to either party. The judge has not reached a conclusion and you put it out. So, of course, in physical court, if you're there, but but it's not retained. So whatever you see, it sort of dissolves after the hearing is over, unless the judge pens down his judgment. So the kind of protocol that has been put in place, I think, would best serve the purpose with which it was construed, and would also allow judges to speak freely. You must understand, in the Indian system, where you have so many cases, often judges make suggestions, like in a family dispute matter. There's a husband-wife dispute, you make suggestions, you try and persuade. And if you are able to persuade, then you arrive at perhaps a settlement, correct? But if these proceedings are live streamed without the consent of the parties, the two people who are in court or someone who's watching the proceedings would actually take a bit of the proceedings and circulate it to the detriment of the litigants, and perhaps also embarrass the judge, because the judge has not reached a conclusion. He's making a suggestion. If the parties are not able to settle, the judge will write a judgment. Now, suppose the judge writes a judgment which is against one of the other party because he was not able to persuade them to come to a settlement. Then the litigant who's lost will use this to somehow portray that the judge was suggesting something in court which I did not agree, and therefore maybe ruled against me, not knowing that the judge was only trying to tell him, having read the papers, that this is the best outcome if you settle. If you don't settle, then we'll see what to do. So I think we should take a call on how to nuance it a little bit more. That's my view.
Justice Shakdher, the Delhi High Court recently got a humor in court page, which was your brainchild. Please tell us how this idea came about, and why is it important to have some humor in court. But also, I may add this caveat that all the law portals were very sad because that was only our exclusive domain till now, to put out the humor in court. But now we have so much of humor in court coming on from that page. Sometimes our reporting falls behind that to match that. So, but anyways, going off track, how does it? How did you think of having that page, and why is it important to have some humor in court proceedings?
So there is a little bit of a history to this. When I was in the Madras High Court, I was called to deliver some kind of talk to the bar, and I have always, in a sense, wondered whether when judges come to the bar and they give a lecture, especially in the evening or during lunch hour, are lawyers there as captive audience, or do they really want to be there? So I told the members of the bar there, listen, I'm not going to give them a lecture, in a sense, about the any particular legal topic. It'd be better if we talk about some humorous incidents that have happened in court. And that's where it all began. And believe you me, after the conversation was over, I don't like these kind of interaction with the bar to be called as lectures, because these are more like conversations. There was a senior member of the bar and his wife, who's also a lawyer but not practicing. I can tell you the senior member's name, Mr. Krishnan. His wife presented me with a book of humorous incidents which had happened, which had been recorded in that book. So when I came to Delhi, and as a head of the IT committee, we did some very, very serious work, including something that has been missed actually, Roy, by most courts, is that we have set up a data recovery system, a facility in Madurai.
Okay.
The reason that we have done that is that Delhi is on a seismic zone, and God forbid if something were to happen in the city of Delhi, the court should be up and about as it was insofar as digital record is concerned. Was grateful to the judges of the Madras High Court for giving us that space. And I think Delhi High Court is the only court which has this kind of a backup. So, so just coming back to the topic of humor, after towards the end of my tenure, so to say, when I was reaching that juncture, this was something that I wanted to do. So I discussed it with my committee members, who readily agreed, and in fact told me about a lot of incidents, some mentionable, some not mentionable, which are only meant for the canteen. And we decided to do this. And we unveiled it in the canteen. See, that's again another thing that we were very clear about, not going to any auditorium, etc. We unveiled it in the canteen where lawyers knew about it. And I was the first contributor, because I said, you have to get over the initial hesitation. So if you go to that site, the first contribution is mine, which was related to me by a senior judge of that court, who of course is now demitted office. So, and according to me, there has always been humor in court. In fact, in the 50s and 60s, there were doyens like Mr. Daftari, Mr. Sikulwad. We had great, outstanding judges. And if you go through books written on humor in court, you'll realize there was always humor in court, which only needed to be sort of put out there, not only for the lawyers to enjoy, but for the common litigant also, if he was interested, or a legal scholar. So it is also my view that when you upload these incidents that happen in court, it also gives you a sense of what the court was at a particular point in time.
Right.
Who were the people who were in court?
Absolutely.
So every court should do it, according to me. Every high court should do it, and we must lighten up. I mean, yes, we discuss very serious matters, but should not make it a life and death issue unless it's a criminal matter dealing with.
Of course. Of course.
There are very serious issues, but it helps judges especially in Indian environment, to deal with even serious matters in a in a very light atmosphere, and judges remain
And it breaks the monotony
monotony,
also.
and lawyers remain officers of the court. They banter and then say their piece and go out. That's what court should be about.
That was the idea.
That was the idea.
Um,
And by the
just
way, even bar and bench can contribute to it, because when you're in court and you see any of these incidents, uh, which can be reported, bar and bench in fact reported one such
well, we
incident.
contribute first to Twitter, and then probably we'll come to Humor in Court page.
Whatever.
But yes, but that page is a tough competition to all the law portals, because all the lawyers giving their input on it will not be able to match that speed. Um, Justice Shakdher, we've come to the very last part of the interview, but I have to ask this: what is that one thing in the last close to 17 years of your legal profession you think you could not do?
Okay. There's a more lighter answer to a very serious question that
Okay.
you asked me. Is when I was at the threshold of being appointed as a Chief Justice of the Himachal Pradesh High Court, and one was not certain when the notification was going to be issued, or followed by or when the warrant would be issued sequentially in that order. There was a litigant who appeared in person before me, because my roster included family law matters. And there was this lady who got up and said, since the buzz was in the air, she got up and said in Hindi to me, "Sir, आप मेरा केस सुन के जाइए, please." So I was telling my bench partner that perhaps the gods are listening to her and it's not happening. So well, you could say that that is one thing that I couldn't conclude, because after some time, within a week, it happened. So maybe, because for me, each matter is important, even if not for the judge, for the litigant, it is important. For her, it was a very important matter.
Right. And
It
she
was,
really wanted you to hear the case.
yeah, she said it in a innocence. I mean,
Yeah, of course.
it wasn't meant that
Was her case adjudicated and
No,
decided?
no, it couldn't. As I said,
Oh, okay.
it couldn't. And yeah, if I had done it, maybe.
Okay. Justice Shakdher, just a connected question only. What was your finest moments as a judge? Is there any moment that you hold very close to your heart and you feel that, okay, this is why I became a judge and today I accomplished it?
No, there is no one moment. In a sense, each judgment that you do, you put your heart and soul in it. There are some tough calls that you take. So, just to cite an example, I did a matter where a lady had taken recourse to surrogacy. She was a government servant, but under the rules, she was not being given leave because she was not the birthing mother. And I found that very strange. Sometimes these judgments don't, really get the kind of, let's say,
Coverage?
coverage, or they just sort of pass by people till they pick it up as a precedent to be cited in other cases. And I did interfere. And for me, that matter was also something that I cherished, the result, that I could make that difference to lots of uh, people who will take recourse to surrogacy and be able to take leave,
Right.
as would a birthing mother. There are several other cases which are close to my heart. But as I said, it is for you, Roy, and others like you to evaluate whether I came through.
But if that case is the one that's coming to your mind the first, then perhaps is the most. Because you deal with so many cases to, fish out that one case.
Yeah, I just gave it as an example. I was tested to the hilt, Roy, when a person came to court and said, uh, my mother needs a transplant, and there is an donor, which was a permission that was not granted. Uh, Everyone's kith and kin is dear to them. This person's mother, like anyone else, would have been dear to them. And he was. But then when I started hearing the matter, I called the donor to the chamber to ascertain whether she had given her consent voluntarily. I realized that she was a person of modest means. She had, I think, three daughters. The husband was an auto rickshaw driver. So when I questioned her, I felt that this was not voluntary. The consent was not given voluntarily, and that there was perhaps some economic need which persuaded her to do that. But when I was sitting to write down the judgment, I was caught between this emotional crisis of what the petitioner before me wanted for his mother, and what I thought was not something that was in the best interest of the donor. And I remember I began that judgment with the incident that Justice Learned Hand had when he was going to court in a carriage driven by his friend, uh, and he got down from the carriage. He was told, "Judge, do justice." And Justice Learned Hand turned around and said, "Justice according to law." So,
poignant one, actually.
yeah, and that gave me a certain clue as to how I should proceed in that matter.
Sure.
Although it's also been my view that if law and justice are too far apart, then the common man doesn't understand that. They have to coalesce. But in a case like this, it gave me, let's say, some guidance as to how I should proceed.
Right.
And not get swayed only by emotion.
And the final outcome becomes very important in cases like these.
Yeah, it does. It may be harsh for one party, but that's your job as a judge. I mean, as a lawyer, if I was a lawyer, I would plead for the petitioner and try and do my best. But the difference between a lawyer's job and a judge's is that we put pen to paper.
Right.
No one likes deciding in tough situations.
Justice Shakdher, in the last decade or so, if there is one particular or two or three Supreme Court cases which you would have decided differently if you were in the apex court, which ones would they have been?
See, Roy, I don't want to theorize. I'm not there, so I can't.
No, but there would be
I can't
any
really,
case? As a judge.
As a judge, I would have decided differently. No, I also believe. See, this is what I said to you just now. Unless you have full insight into what the matter is about, see, judgments only represent, um, let's say, a part of what was argued, what was then appreciated and then translated into a conclusion. Especially in an adversarial system, when you're sitting as a judge, it is important to appreciate the arguments as they are happening. And for someone who reads a judgment later on, may think that he would have come to a different conclusion, may or may not be true. It is when you are sitting on that hot seat and deciding the matter, it is then you could possibly come to a conclusion. But as I said, that whatever conclusions that you arrive at, it is fair for people to come to a different point of view, especially the scholars and even the litigants. But that's something that a judge lives with. So I cannot say that I would have come to a different conclusion unless you are living that case. It is very easy for people to say that I would have decided differently. Like, for example, the judgments that I have written, if people didn't agree with that, they would have said I would have decided differently. But they don't know what was the full scope of the arguments, because you can't replicate everything.
Absolutely.
So
Right.
that's my short answer to it.
Justice Shakdher, this is my last question to you. You were in court yesterday getting a proximity card done. So you're very much getting back to the profession, to the bar. And so the first part of my question, that what you think of post-retirement jobs, does not really suffice. My question to you is, what have you learned as a judge in these 16 years that would make you act and work a little differently as a lawyer now? Is there anything that you now would do differently than senior advocate Shakdher used to do before he was elevated?
Yeah, that's a good question. See, being on a bench for over 16 and a half years, one thing has certainly changed is that I would understand perhaps better the perspective of the other side in difficult situations, and then try and convey to the court uh, side I'm representing their point of view. And if in the process I fail to persuade the bench, I would perhaps understand their compulsions from a legal point of view. Because judges, after hearing both sides, need to come to a conclusion one way or the other. And not every conclusion should be taken to heart as a lawyer. I'm sure they don't do it even now, but I have a better understanding uh, of what the role of an adjudicator is, being on that side. That sometimes they go by the letter of the law, and sometimes they fine tune the law, as I say, remove the creases and the wrinkles, and then come to a conclusion. Right. So both tools are available to them. We represent as lawyers only one side and try and do our best, but judges then look at both sides and then come to a fair conclusion. So that is something that I would now, having matured both in age and otherwise, perhaps appreciate that better and take a decision as it comes.
Right, right. Thank you so much, Justice Shakdher, for being with us in this interview series, and we're very grateful to you for your time.
Thank you.
Thank you so much, sir. Thank you.